So a week or so ago, I brought you the motion to dismiss that was filed by H3H3 or TED Entertainment, the Kleins, against Triller, who is suing them over this whole Ben Askren, Jake Paul fight thing. And in that video, I alluded to there being a Superior Court of the State of California action also brought by Triller with some kind of tortious interference with a contract or business relations or something as its goal. And H3H3 had asserted in their motion to dismiss that this whole thing, including the California County Court action, were all part of a strategic lawsuit against public participation. A SLAPP is what they call it. So here is the anti-SLAPP motion. So here we are. This is a special motion to strike plaintiff's first amended complaint. That's how most anti-SLAPP laws are written, that you file some kind of motion to dismiss or motion to strike. Motion to strike is basically the same thing as a motion to dismiss. If you strike enough of the plaintiff's allegations, then they no longer have a claim, and therefore the thing has to be dismissed. That's what you want. But a motion to strike can also be much more narrow. Let's say somebody has a complaint and they say X happened, Y happened, Z happened, and the defendant is a jerk. I mean, literally, they say that. Let's just pretend for a moment, hypothetically. They say XYZ, a defendant is a jerk. Well, defendant is a jerk is not something that helps the case one way or the other. It doesn't make something more likely to be true, less likely to be true. It's not really relevant. It's salacious. It's inflammatory. So you can file a motion to strike. And it doesn't mean that X, Y, and Z get dismissed, but it does mean defendant is a jerk gets dismissed or gets stricken from the record. And the court will act as if that sentence doesn't exist. So you're building the court's record for the court to later review. That part's gone. So in this case, with a anti-SLAPP motion as a motion to strike, they're going to strike the SLAPP part, and there won't be anything left. So it's effectively a motion to dismiss, which is why I say that. And there's a bunch of stuff here, table of contents, citation to authorities. This is all stuff that helps the court and is often required by the court. We're going to jump straight to the memorandum. Free speech for me, but not for thee. This is the theme of the relentless campaign by Triller and its majority owner Ryan Kavanaugh to harass, punish, and silence defendants for exercising their First Amendment rights. Triller and Kavanaugh have repeatedly abused the judicial system to silence commentary and criticism made about them on the TEI production. I think that's TED Entertainment, which is the H3 podcast. This assault on defendants' lawful criticism began by Triller and Kavanaugh, causing a Triller subsidiary, Triller Fight Club 2 LLC, to sue defendants for copyright infringement because the H3 podcast used a short clip of the Jake Paul v. Ben Askren fight for commentary and criticism. Triller and Kavanaugh are now suing defendants for their lawful speech criticizing the copyright action, Triller's social media application, and Kavanaugh. The First Amendment complaint is both confused and confusing. It's chock full of irrelevant allegations and Rube Goldberg-like legal theories devoid of merit to disguise its direct assault on speech protected by the First Amendment and statutes intended to promote the same. Fortunately, California's law, Section 425.16, the Anti-SLAPP statute, empowers this court to prevent Triller's and Kavanaugh's attempt to improperly use the judicial system to harass, punish, and silence defendants' lawful speech. Prong 1. Triller's cause of action arises from protected activity as defined by the Anti-SLAPP statute. The foundation of Triller's claims are statements made on the H3 podcast about Triller, the Triller app, and Kavanaugh, all of which are matters of widespread public interest. The H3 podcast has millions of subscribers, and the episodes at issue received millions of views. The Triller app has hundreds of thousands of reviews, millions of downloads, millions of monthly users. Triller, the app, and Kavanaugh have also been the subject of countless media reports. Therefore, there is no question that Triller's claims arise from protected activity as defined by the Anti-SLAPP statute. Prong 2, Triller cannot demonstrate that it has a probability of prevailing on a single cause of action. First, the FAC, First Amended Complaint, alleges that the H3 podcast incited its viewers by asking them to download the Triller app and leave an honest review. Under the First Amendment, incitement is actionable only when the advocacy is intended to and directed at creating imminent lawless action. And we've done a video on this. This is called the Brandenburg Line, and there's other First Amendment cases as well. But the speech must be targeted at and intended to create imminent lawless action. So asking someone to download an app and leave an honest review, that's not lawless action. You're allowed to do that. So it's not some kind of illegal incitement. Directing viewers to leave an honest review, negative or positive, is protected speech. Second, Triller's causes of action are defamation claims in disguise, because they are predicated on Triller's allegations that the H3 podcast made false, misleading, and malicious statements. As such, Triller must overcome the First Amendment protections for defamation law, which it cannot do. Each statement identified by Triller in the complaint is either true, or protected opinion, or not of and concerning Triller, or not made with actual malice, all components of defamation law. Third, Triller seeks to impute third-party statements from the H3 subreddit onto defendants because they are moderators of the subreddit. But Section 230 of the Communications Decency Act bars Triller's attempt to impose liability on defendants for statements made by third parties. Finally, Triller fails to properly plead and cannot prove any facts for any of its causes of action. Indeed, one of the causes of action has been explicitly rejected under California law. Stripped bare, it is readily apparent that Triller's First Amended complaint is an attempt to subvert the judicial system to harass, punish, and silence defendants for their First Amendment protected criticism of Triller, the app, and Kavanaugh. The express purpose of California's anti-SLAPP statute is to prevent courts from being an accessory to such perversions of justice. Therefore, for the reasons stated below, defendants respectfully request this court to grant their motion and strike the amended complaint in its entirety with prejudice, which means the thing is dismissed and couldn't be brought again. With prejudice means the claims are extinguished in their entirety. So the defendants are TED Entertainment and Ethan Klein, an H3 podcast, and Teddy Fresh is a streetwear fashion company entirely separate and not involved with the podcast. Ethan does wear Teddy Fresh products in nearly every episode to promote Teddy Fresh. Triller owns the Triller app and is the parent company of Triller Fight Club 2. The app is on Apple and Google Play. Lots of views, lots of downloads, reviews, etc. Ryan Kavanaugh is the majority owner. He was former CEO of Relativity Media. He drove the company into bankruptcy twice, according to this motion. During Kavanaugh's tenure, Relativity was reduced to a mere $30 million in assets with nearly $600 million in liabilities. That's a bad asset to debt ratio. Despite their insolvency, Kavanaugh made Relativity pay him a $2.5 million consultant fee. In arbitration, the Honorable Terry Friedman found that Kavanaugh fabricated a memo alleging sexual harassment against the former president of Relativity, Adam Fields. In that same arbitration, Kavanaugh falsely testified under oath that the memo was authored by a former in-house counsel at Relativity. In retaliation for exposing his false testimony, Kavanaugh sued Mr. Fields. Wow, if that's all true. I'm just reading this. I don't know the veracity of those statements. Kavanaugh has been embroiled in several other public controversies. For example, his nanny was forced to sue him after he refused to pay her. I'm assuming that's the nanny for his children and not his nanny. In an executed, verified complaint drafted by Sidley Austin LLP covered by the press, Kavanaugh's former business partner Elon Spar called Kavanaugh's new business venture a Ponzi scheme. Kavanaugh has been arrested twice and convicted once for driving under the influence. These controversies have caused Hollywood to shun Kavanaugh. As the CEO of Solstice Media said of him, every time anyone lies in cans, Ryan Kavanaugh gets a royalty. On April 17, 2021, Triller Fight Club 2 streamed the fight over the internet. TEI and its employees watched the fight over the internet to prepare an H3 podcast episode that would comment on and critique the fight. After the fight, TEI found on YouTube a clip of the fight's main event, the fight between Jake Paul and Ben Askren. Okay, so according to that, the clip was not uploaded. They found it on the internet. TEI copied the clip, and uploaded it as an unlisted video, a video that could only be accessed by knowing the URL, to facilitate the commentary and criticism of the fight on the podcast. On April 22nd, the podcast lambasted the fight by using 44 seconds of the uploaded clip of the fight to illustrate the cast's biting commentary and criticism. On April 23rd, Triller initiated the copyright action against multiple defendants for alleged copyright infringement of the fight. On April 29th, Triller filed an amended complaint. The sole additions were the two channels owned by TEI. On his own, Judge Percy Anderson dismissed the channels and several other defendants for improper joinder. Judge Anderson wrote that Triller Fight Club 2's repeated failure to properly plead joinder calls into question the adequacy of plaintiff's compliance with its pre-suit obligations under Federal Rule of Civil Procedure 11, which is the one that we keep talking about with ethical concerns. You have a duty of basic due diligence to make sure you're filing the thing for a proper purpose and not an improper purpose. Triller took to the media to malign the H3 podcast to scare third parties into participating in Triller's settlement program. In the article, Triller's head of piracy, Matt St. Clair, made false statements of fact and law about the H3 podcast's potential legal exposure for statutory damages for copyright infringement. On May 10th, Triller filed a new complaint solely against the H3 podcast. In conferring regarding the lawsuit, Triller's counsel repeatedly emphasized that Kavanaugh was the main force behind the lawsuit. May 18th, TEI disclosed its identity to Triller after an improper attempt at service. May 21st, Triller filed an amended complaint that named TEI and Ela and Ethan under an alter ego theory. On June 29th, the defendants sent Triller a detailed letter explaining why each claim set forth in the copyright action failed as a matter of law, and how Triller violated Federal Rule of Civil Procedure 11 because the amended complaint and their prior correspondence contained countless false assertions of fact and law. Triller ultimately agreed to drop 3 of the 6 claims, yet added Teddy Fresh as a defendant. To avoid burdening the court with an anti-SLAPP motion and addressing claims Triller had conceded lacked merit, defendants stipulated to the second amended complaint. On September 6, defendants filed their motion to dismiss the second amended complaint. After learning of the copyright action, the H3 podcast discussed Triller, the app, and Kavanaugh. TEI released an H3 podcast episode that discussed Kavanaugh being behind the copyright action, a Variety magazine article that reported that Mr. Spar accused Kavanaugh of running a Ponzi scheme, and whether Kavanaugh physically resembled Harvey Weinstein on the June 11th podcast. On July 1st, TEI released another episode that discussed the same topics, and that Ethan tried the Triller app and gave it a 1-star review. On July 2nd, they released another podcast episode discussing the same topics as before, plus that Triller misrepresented Kevin Hart's presence on the Triller app, the contents of Ethan's review of the Triller app, a video of Noah Beck, a social media influencer, in which Mr. Beck stated that the Triller app was flipped because the camera function was inverted, and the Triller app and how viewers should download it and provide an honest review. On July 8th, another episode discussed those topics, plus chastised troll reviews of the Triller app and instructed viewers not to give troll reviews of the Triller app. The June 11th podcast receives 2.5 million views, the July 1st 2.3 million, the July 2nd 1.9 million, and the July 8th 1.2 million. Defense counsel and Triller's counsel agreed to meet and confer July 14th to discuss why the copyright action failed as a matter of law. July 14th, Kavanaugh sent defendants a demand for retraction, which failed to identify a single alleged defamatory statement in the various podcasts. Approximately 30 minutes before the parties were to meet and confer, Triller sent defendants an initial version of the first amended complaint. Triller's counsel sought to hijack the meet and confer to discuss Kavanaugh's threatened defamation lawsuit and the present action, which I'm assuming is this tortious interference action. But defense counsel insisted on discussing the deficiencies of the copyright action. Triller filed a complaint July 19th and an amended complaint September 7th. Under prong 1 of the anti-SLAPP statute, the defendant must establish that the challenged claim arises from activity protected by the law, by 425.16. If prong 1 is satisfied, then, under prong 2, the burden shifts to the plaintiff to demonstrate the merit of the claim by establishing a probability of success. The anti-SLAPP statute is to be construed broadly, and it is designed to encourage participation in matters of public interest by targeting lawsuits brought primarily to chill the valid exercise of the constitutional right of freedom of speech. Prong 1. Under prong 1 of the anti-SLAPP statute, a claim arises from protected activity when the activity underlies or forms the basis for the claim. This requires evaluating the context and content of the asserted activity. Section 425.16(e)(3 defines protected activity as any written or oral statement or writing made in a place open to the public or a public forum in connection with an issue of public interest. Websites accessible to the public, like YouTube and Reddit, are public forums for purposes of the anti-SLAPP statute. Section E4 defines protected activity as any other conduct in furtherance of the exercise of the constitutional right of free speech in connection with a public issue or an issue of public interest. There are 3 non-exclusive and sometimes overlapping categories of statements within the ambit of E4. 1. Statements or conduct concerning a person in the public eye. 2. Conduct that could directly affect a large number of people beyond the direct participants. And 3. It involves a topic of widespread public interest. Here, Triller's claims arise from statements made during the H3 podcast and from third parties on the H3 subreddit about Triller, the Triller app, and Kavanaugh. Courts have routinely found that acts that advance or assist the creation and performance of artistic works are acts in furtherance of the right of free speech for anti-SLAPP purposes. It is self-evident that the statements made in the podcast were part of the creation and performance of an expressive work. The podcasts. The podcasts implicated several matters of intense public interest, such as the H3 podcast, Triller, the Triller app, and Kavanaugh. The First Amended complaint concedes that the H3 podcast is a matter of widespread public interest by admitting that the podcasts were recorded and published to the podcast's YouTube channel and millions of subscribers. Further, each of the podcasts have received anywhere from 1.2 million views to 2.5 million views. Therefore, the H3 podcast in general, and the podcasts in particular, are matters of widespread public interest. Triller and the Triller app are also matters of widespread public interest. Triller and the Triller app have been the subject of countless media reports. The app has received hundreds of thousands of reviews, millions of downloads, and millions of monthly active users. There can be no doubt that Triller and the app are in the public eye and are matters of widespread public interest. Kavanaugh is also an individual of intense public interest. He has been the subject of countless media reports, including his personal life, misdeeds, mismanagement of Relativity Media, and majority ownership of Triller. Therefore, Kavanaugh is a person in the public eye and a matter of widespread public interest. Defendants have met their burden under prong 1 of the anti-SLAPP statute. Under prong 2, Triller bears the burden of proof to establish that there is a probability that it will prevail on the claims. This requires Triller to demonstrate that the complaint is both legally sufficient and supported by a sufficient prima facie or basic showing of facts to sustain a favorable judgment if the evidence submitted by the plaintiff is to be credited. To carry this burden, Triller may not rely solely on its complaint, even one that's verified, as in other words, signed by the proprietor of the company or plaintiff. Instead, proof must be made upon competent, admissible evidence. Even if Triller satisfies this burden, its claims will be dismissed if defendant's evidence defeats the plaintiff claims as a matter of law. Triller's first amended complaint is premised on the allegation that the podcasts incited unlawful activity by encouraging viewers to leave one-star reviews of the Triller app. These allegations fail as a matter of law because the speech at issue is fully protected by the First Amendment. The First Amendment protects parody, rhetorical hyperbole, and loose, figurative, or hyperbolic language. The First Amendment does not permit a state to forbid or prescribe advocacy of the use of force or of law violation, except where such advocacy is directed to inciting or producing imminent lawless action and is likely to incite or produce such action. So I've called that the Brandenburg line here. Here the defendant is citing to Virginia v. Black from 2003. As a threshold matter, advocacy of leaving a one-star review is protected speech. Even were we convinced that a one-star rating could be understood as defamatory, that this is a premise we do not embrace. Further, the First Amended complaint explicitly concedes Triller cannot meet the standard for incitement because the complaint itself admits the podcast contained the following statements. People should judge for themselves. Go download the app and leave a review. Give Triller 1 or more stars, some amount of stars between 1 star and up to maybe 5 stars. Not to leave troll reviews or brigade Triller with troll reviews. This language clearly does not advocate for any lawless action. Therefore, Triller cannot show a probability of prevailing on its claims because the speech used in the podcasts do not constitute incitement and is fully protected by the First Amendment. Requirements for defamation. Triller's causes of action are defamation claims in disguise, because the First Amended complaint repeatedly alleges the causes of action are based on false, misleading, and malicious statements made in the H3 podcast. When the gravamen of a claim is an injurious falsehood of a statement, those claims are subject to requirements rooted in the First Amendment of the U.S. Constitution for a defamation claim. These requirements cannot be avoided by creative pleading that affixes labels other than defamation to injurious falsehood claims. Triller cannot satisfy these First Amendment requirements as discussed below. Triller is and Kavanaugh runs a Ponzi scheme, is the quote. This statement fails to meet the First Amendment requirements for defamation. Foremost, this statement was never said in the podcasts. Rather, examining each of the podcasts as a whole, it is apparent that the podcasts accurately discussed the accusations Mr. Spar made in his 2019 verified complaint against Kavanaugh and Proxima Media, past tense, not present. Therefore, Triller cannot show that this statement was even made, let alone that it was false. Further, this statement is not of and concerning Triller, rather it is a statement of and concerning Kavanaugh and Proxima Media. In defamation actions, the First Amendment also requires that the statement on which the claim is based must specifically refer to or be of and concerning the plaintiff in some way. Finally, even assuming, arguendo, that Triller could satisfy the aforementioned requirements, Triller cannot prove the constitutional requirement of actual malice. Due to intense media scrutiny, Triller and Kavanaugh are public figures who must plead and prove actual malice. The all-purpose public figure is one who has achieved such pervasive fame or notoriety that he or she becomes a public figure for all purposes and contexts. As such, they must prove, by clear and convincing evidence, that an allegedly defamatory statement was made with knowledge of falsity and reckless disregard for the truth, which I think that's the actual malice standard. Here, the statements in the podcasts were based on a Variety article and Mr. Spar's verified complaint. There was no definitive proof Spar's allegations were false. For these reasons, this statement is not actionable. Next quote, Triller falsely represented that comedian Kevin Hart uses the app. This statement is true because when the podcasts aired, Triller's descriptions for the Triller app stated that, quote, millions have made Triller videos along with huge global stars such as Kevin Hart, despite Mr. Hart having no presence on the Triller app at the time the podcasts were made and aired. Indeed, Triller effectively concedes this point by removing Mr. Hart's name from the Triller app's descriptions on the Apple Store and the Google Store after filing this lawsuit. This statement is not actionable. Quote, that the app is flipped. This statement was originally made by Mr. Beck, a prominent social media personality, as he was creating a video using the Triller app. In the video, Mr. Beck stated, "Yo, Triller, my thing is flipped." because he was experiencing issues with the Triller app's camera function. Therefore, insofar as this statement contains an assertion of fact, it is true and not actionable. But further, this phrase is non-actionable opinion under the First Amendment. Mr. Beck expressed his opinion on the Triller app's functionality, that the camera function was not working because it was inverted. Finally, even assuming, arguendo, this constituted a false assertion of fact, Triller cannot show actual malice because the statement was based on Mr. Beck's statement in his video, without any evidence demonstrating that defendants knew Mr. Beck was incorrect. Next quote, Mr. Kavanaugh bears a physical resemblance to Harvey Weinstein. If beauty is in the eye of the beholder, the same holds true for the lack thereof. This statement constitutes non-actionable opinion because it expresses the subjective perception that Mr. Kavanaugh looks like Mr. Weinstein, to which some H3 podcast members agreed and some disagreed. Further, this statement is of and concerning Mr. Kavanaugh and not Triller, so therefore this statement is not actionable. Quote, Mr. Kavanaugh sued defendants. This statement is substantially true. Triller's counsel told defendants' counsel that Kavanaugh was behind the copyright action and the present action. Further illustrating Kavanaugh's involvement are the First Amendment complaint's numerous allegations of false, misleading, and malicious statements concerning Kavanaugh and not Triller. 2, Triller's counsel sending Kavanaugh's retraction letter. And 3, that Kavanaugh is the majority owner of Triller and its subsidiaries. Further, this statement is of and concerning Kavanaugh, not Triller. Finally, even assuming arguendo that this statement is false, Triller cannot prove actual malice because Triller led defendants to believe Kavanaugh was behind the copyright action and the present action. Therefore, this statement is not actionable. In sum, Triller cannot show a probability of prevailing on its claims because none of the statements identified in the First Amendment complaint meet the First Amendment requirements for defamation. Triller's claims under Section 230 of the CDA. Triller's causes of action are also premised on the theory that defendants are responsible for statements made by third parties on the H3 subreddit because defendants serve as moderators of the subreddit. Section 230 explicitly states, no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. The plain language of Section 230 applies to users of a website like Reddit, including individuals. Further, courts have consistently held that Section 230 confers users of websites broad immunity from tort claims based on the speech of a third-party user. Here, Triller seeks to impute statements made by third-party users of the subreddit onto defendants because they are moderators. Therefore, Triller cannot show a probability of prevailing because Section 230 bars imposing liability on defendants for third-party statements on the subreddit. And even if there wasn't Section 230, because I know that there's sort of this trend every once in a while, it'll, invalidate 230, get rid of 230, overturn 230. There's still other standards for vicarious liability, for imputing liability to a company or a parent or a first party based on the actions of a third party. There are still other standards for that liability. It wouldn't necessarily mean that without 230, every website is responsible for its user-generated content. Triller fails to properly plead any claim. This lawsuit and its claim appears to be for intentional interference with contractual relations. Aside from impermissible legal conclusions, Triller fails to properly plead facts demonstrating 1. A contractual relationship between Triller and a third party, 2. Defendants' knowledge of said contracts, 3. Any intentional act by defendants designed to induce, breach, or disrupt said contracts, 4. An actual breach or disruption of said contracts, or 5. Any resulting actual damages. Therefore, Triller has no probability of prevailing on this cause of action. Its second claim for intentional interference with prospective economic relationships fails. Aside from impermissible legal conclusions, they fail to properly plead facts demonstrating 1. The existence of any stable economic relationship between Triller and a third party that existed prior to the purported interference, defendants' knowledge of said relationship, defendants' wrongful conduct, actual disruption of said relationships, and resulting actual damages. Therefore, Triller can't prevail there. Third claim, negligent interference with existing economic relationships. No such cause of action exists. In California, there is no cause of action for negligent interference with contractual relations. While there exists a cause of action for negligent interference with prospective economic advantage, the California Supreme Court has rejected a cause of action for negligent interference with a contract, so that claim fails. The fourth claim, negligent interference with prospective economic relations. The elements for this cause of action are identical to a claim for intentional interference, with the exception that the third element requires defendant's knowledge, actual or construed, that the relationship would be disrupted if defendant failed to act with reasonable care, and an additional element of defendant's failure to act with reasonable care. This cause of action fails for the exact same reasons set forth above. Triller has no probability of prevailing on this cause of action. Triller's fifth cause is for violation of the California Business and Professional Code. The only purported wrongful conduct alleged in this cause of action is 1. Defendants making and or disseminating false, misleading, or deceptive statements concerning plaintiff to the public, and 2. Defendants' willful and malicious efforts to artificially lower the app's approval rating in the various app stores. For all the reasons stated above, these allegations cannot serve as the basis for a violation there. Triller and Kavanaugh's assault on defendants' First Amendment rights must end. Triller and Kavanaugh have profited handsomely from the First Amendment, and it is time that they learn it does not just benefit them. For the reasons stated above, the court should strike Triller's meritless First Amendment complaint and award defendants their mandatory fees and costs. That will be the subject of a separately filed motion. So that's really interesting. I have continued to maintain that it seems like a really thin lawsuit. The technical violations that Triller might be able to bring up haven't really resulted in any terrible damage or anything. Showing 44 seconds while criticizing Triller and its associates and its people, it doesn't really seem like a copyright violation to me. But this lawsuit is being run with a kind of energy that I don't see from sincere, legitimate lawsuits generally. So in my opinion, this is not a sincere lawsuit that is trying desperately to make the plaintiff who has been injured, make them whole and bring them back to the status quo before they were injured by these terrible actions. Instead, it seems like a cash grab. It seems like somebody sees a potential claim and wants to get the money out of it, or doesn't like being criticized by the defendants. That's what it seems like to me. But we've only read H3H3's motion to strike and their motion to dismiss in the other lawsuit. So maybe we'll have to wait for Mr. Kavanaugh and Triller's response in their response. That'll be the next step. Then the court will end up evaluating that and either granting or denying the motions. What I can tell you is the H3 defendants feel strongly about these motions' ability to win at the motion stage instead of needing to go further into litigation and adjudicate the damn lawsuit. That would make things way more expensive. As it is, I bet you if they've spent the middle 5 digits getting to this spot, I bet you they've had to do a lot of work defending 3 lawsuits now. One was they were dismissed. The first one they were dismissed as a defendant, but then the background things had to happen getting ready for the second one. Then the second one has already had an amended complaint. This one in the county court has already had an amended complaint. So we're actually several steps into this thing and not just one set of responses, but more like 5. So I could easily see this thing being in the mid to upper 5 digits already for them. But I think they're in good hands. Lincoln Bandlow is opposing counsel for me in the piracy cases, and he seems to have written a great motion to dismiss and a great motion to strike. So I actually think this has a pretty good chance of succeeding. I just don't know what the Triller plaintiffs are going to put them through before finally walking away. And of course, now if they've spent a lot of money getting this thing dismissed, then there's also going to be a motion for attorney's fees and costs. So they get to fight over that too. So we're not done with this thing by a long shot. I'll keep you updated. Let me know what you think of this whole thing in the comments below. Do you think that Triller's got a legitimate claim here and that Ethan and H3 really did something legally wrong, legally recognized either the copyright infringement or some kind of tortious interference with a contract or economic relations, or some kind of defamation with what has been alleged to have been done, what we saw with our own eyes for the most part? Or do you think Ethan and H3 are making very good, fair uses of criticizing and mocking the behavior and conduct of the plaintiff parties? Let me know in the comments below. Thank you for watching. Special thanks to our top supporters in September: John Steele, Gavin Barnard, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Torpedan, ShadowTycho, Earthbound Star, PureMagma, Drew Hart, TechTechPotato, and Eric Tams. You can support Lawful Masses on patreon.com/ljfrench, sponsus.com/law, through YouTube memberships, or through Floatplane subscriptions. Join me for our weekly live production stream on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Eastern US time. I hope everyone has a great week. I love you all. Bye. The anti-SLAPP statute, the anti